First of all, thank you for being here for this District 12 Raise the Age Forum. Thank you for being here. I have to say that it's been a long journey to get to this point for North Carolina, and so I just want to make sure that you know how much we appreciate you guys being here. My name is Marjorie Pitts, Chief Ward Counselor. I also want to thank the Department of Social Services for the use of this facilities.
All of us in this room do what we do for a reason. And I dare say every one of the individuals that I'm looking at across this room, I've known you for a number of years. I've known a number of these officials just in passing, but I will get to know Maxine more regarding Nigel shortly. But anyway, and you get up every morning and you do your best and you work hard for others. And we have a lot to be excited about, a lot to be proud about here in Cumberland County. Not just because of you, but your co-workers and others in various programs, court programs, state offices to provide a function to our citizens. We're in good hands. There are a lot of experienced people. They want to do their best. There are several programs that are cutting edge and dozens of other programs that are time-tested when we talk about the juvenile system. And now we have raised the age. Many of us are excited, but as Nigel mentioned, some of us have to be a little bit nervous about it. But there's an old saying that progress never comes when you have to stay in your comfort zone. So it's okay to be a little nervous. It's okay to understand our numbers, Billy, may be a little different from many of the other districts that you've presented to. But we've got some great people, some great working relationships, some great programs, and we're looking forward to continuing that tradition here in Cumberland County. If you think about, and many of you are aware, of all of the, quote, touted revolutionary attempts in focusing upon happenings in our adult criminal justice system, I want you to bear in mind how much comfort we should have as participants in the juvenile system. If you look at expungements and what is going on to allow for greater employability by wiping out, say, multiple dismissals, that notion of having the privacy and not the public scrutiny of a record, that's something that we've had in our juvenile justice system for decades. If you look at court diversion programs in adult court, this is how we have operated in the juvenile realm, yet for adults, it's touted as the new and best and foremost of programs perhaps we could put in place. And we are doing that here in Cumberland County. About every aspect of juvenile justice, tailoring efforts to families and individuals instead of a cookie-cutter approach to anyone 16 years on up to 90, and how we plug them into programs and expect different results from one program as it affects the variety of people that come through our courts. We've done business like that in the juvenile system for decades. So there's much that we have to be proud of. Much here in Cumberland County, but much across the state. And I believe as we listen and welcome, in particular Billy and the other speakers, that we should show them a gratitude and that it is truly a privilege to be partnered and work with them on this exciting time. So with that, I say welcome to Cumberland County, all of you. Thank you.
I think it's important to know that where you are right now, I think it's where we are in the Department of Social Services is a fitting place to hold this event. We're talking about it with DSS in terms of raising the age to 21 in terms of children that are in foster care. We're talking about raising the age in terms of juveniles. And I think it's important that this community and this state understand how important and how a valuable resource our children are. But even more than that, I think it's important in terms of having it here in Cumberland County that we're on the cutting edge in the state of North Carolina. I've got my county manager here, Ms. Amy Cannon. Our county commissioners years ago decided on our application to wipe off whether you were a convicted felon. That's important. My DA, who's here, Mr. Billy West, and Commissioner Charles Evans have done expungement clinics in this community. That's important. Went to Durham, learned about their diversion program before Raise the Age was there, and we implemented that here in Cumberland County. And the reason being is because we understand the collateral consequences of being in a system and being in a criminal justice system. We hope it doesn't end here. There are a lot of collateral consequences. We need to start looking at our bail and fines and all of that within Cumberland County. So this is a starting point. And so today I just welcome you here, tell you that the fight is not over. The fight is just beginning. And with that, I hope you have an enjoyable day. I think you've got an informative day planned. And so thank you so very much.
Good afternoon. Good afternoon. And thank y'all so much for being here today. We appreciate you being here. This is a really important issue that's changing the state of North Carolina. We're looking at raising the age, and this is not a new topic in the state of North Carolina. In fact, the original juvenile code in the state of North Carolina was passed in 1919. In 1919, there was a group of women that were meeting that was called the King's Daughters, and that group of women were walking down the street one day to one of their meetings, and on the way to the meeting, they saw a chain gang on the side of the road, and that chain gang had 40 and 50-year-old men working right beside 8 and 9-year-old kids. And they thought, well, something doesn't make sense here. This doesn't seem like the appropriate way to treat children in the state of North Carolina. It just so happened that a number of their husbands had credentials of being a legislator, and so they went to their husbands and said, you need to do something about this. And lo and behold, in 1919, we passed the Juvenile Justice Act in the state of North Carolina. In 1935, the governor and the General Assembly got together with the Chief Justice and said, let's go back and see how this is working. Since we passed this in 1919, it's been about 16 years. Let's look and see how it's going. Are there any changes that we need to make? And they pulled together a task force to look at how do we want to change the juvenile justice system in the state of North Carolina. Are things going right? Are there things that we need to tweak to the law? And their very first recommendation was to raise the age in 1935. They said we should raise the age from 16 to 18 in 1935. But there was this thing going on in the country at the time, you might have heard of it. It was called the Great Depression. And because the Great Depression was going on, the legislators said, well, we want to do it, but we don't quite have the resources right now, so come back to us when the Great Depression is over, and we'll see if we can fund this thing and raise the age in the state of North Carolina. So about 100 years later, we got there. All right? And so we're really excited about this change. I'm going to talk to you today about why did we do it? What is it going to mean for your local county? I'm going to show you your local numbers, exactly what we are expecting as far as new juvenile cases in your county. We're going to talk about what that means as far as additional resources that are needed in your county to deal with that additional population. So we'll talk about that. And then we're going to also dig into what was actually included in the legislation. Last year there were actually 6 different bills introduced in the General Assembly to look at raising the age. The final bill that actually passed was the budget bill. Raise the age was put into the budget bill as a special provision, and so it's 15 pages of a 600-page bill. So unless you dug really deep into the legislation, you may not have found it. And so I think it's important for us to go over what was actually included in the legislation. So that's kind of the agenda that we're talking about today. After we get done with that part of the presentation, we're going to take questions from you. We're going to take your questions, your comments, your recommendations, because a big part of what this is all about is that we asked the General Assembly to give us more time. At first, when the bill was first introduced last year, it was supposed to go into effect last July 1st. And we said, whoa, wait a second. That's not nearly enough time for us to plan and get ready for raise the age. In fact, there was no time to do that. We told them we needed at least 2.5 years to put in place plans and come up with all the facilities and all the resources that are necessary to deal with raise the age. And so they did give us that time. The actual bill itself does not go into effect until December 1st of 2019. And as part of that planning process, we made a commitment that we would come to every juvenile, or actually every court district in the state, and have a conversation with local stakeholders about what this will mean for you guys. And that's part of this process that while we're here today. And we want to hear from you guys about additional recommendations, additional tweaks to legislation that you may think are necessary, additional resources that you may think are necessary. Because we know most of the time when legislation is passed in Raleigh, They pass the legislation, it's pushed down to the local level, and there's no explanation or no resources or no talking about how do you do this in your local county. And we wanted to make sure this process was different. We wanted to make sure that your voice was heard in the process, but also that you had time to plan and think through how you could do this at the local level. So that's the third thing that you see on the fourth thing that you see on the agenda. We'll go over some of those comments, questions, recommendations, and then we're going to stick around for a little while. If you're if you're one of those people that don't want to ask a question in front of the whole group, that's fine too. We're going to stick around and we'll answer additional questions that you may have after the presentation on a one-on-one basis. But I will tell you that we got people up here in the front that are going to be taking notes, and we will take all your recommendations back today to be heard by the Juvenile Jurisdiction Advisory Committee, which was also created by this legislation. That committee has been tasked with making additional recommendations to the legislator about what needs to be done to make sure this is implemented correctly in the state of North Carolina. So we do hope that you'll participate in the process. So first of all, let me talk about a couple of myths. The first one, as I said, this hasn't been planned for. Well, as you heard, we've been having this discussion in the state of North Carolina for a long time. 1935, that's a long time to be having a discussion. And I can tell you, over those years, there's been a lot of discussion about how this could be done. What would it look like across the state of North Carolina? There have been a number of task forces that have recommended this and have thought about what it would take to raise the age in the state of North Carolina. And we are the last state in the country to do this. All right, every other state in the country, all 49 other states have already raised their age. So we are the last state in the country to do this. Because that is the case, we've learned a lot of lessons from other states about how to do this correctly. So there's been a lot of planning that's gone into the process. The second one is that the system is going to be overwhelmed on day one with all these new juveniles on the very first day that it's implemented. That's not how this legislation works. It does not grandfather kids back into the system. So if they're under adult supervision today, or they're under adult supervision on November 31st of 2019, they will still be under adult supervision on December 1st of 2019. It's only the new juveniles, the new incidents that occur, or new crimes that occur, that will enter the juvenile justice system. It does not retroactively bring kids back into the system. And that was important to us because we didn't want 7,000 kids to show up on the very first day. The last one is that we're going to house really young juveniles with older juveniles. We're working on plans right now to figure out how to house the juveniles across the state of North Carolina. You're very fortunate that you have a detention facility right here in Cumberland County. And because of that, that is a resource that you have available to you that it cuts down on transportation costs and resources that are needed. But we are looking at how do we want to house these different populations moving forward, and we're coming up with plans to do that, and I'll talk more about that as we go through the presentation. So you heard from the judge, and you also heard from the county commissioner all the reasons why we did this. I don't know that I need to go through a lot of this again because you heard about it. But the biggest one that I want to emphasize with you is public safety. Why do we raise the age in the state of North Carolina? Because we believe this will make the state of North Carolina safer. How does it do that? It reduces recidivism. What is recidivism? The chances of that individual coming back into the system again, getting rearrested later in life. By keeping a juvenile in the juvenile justice system versus putting them in the adult system, you reduce recidivism by almost 12.5%. There are economic savings, and I'll show you some charts that show you some of the economic savings in just a minute. Juvenile employability, I think the county commissioner talked about juvenile employability and why that's so important. But if you want to give a young person hope, you have to give them a hope for the future. That they can be successful, that they can be employed in the future. And in order to do that, they can't have a record for the rest of their life that's going to stick with them. Young people that get arrested in the state of North Carolina right now, if a young person tonight got in a fight at school and got arrested for it, and they're 16 years old, and that exact same child, or let's say he had a twin in South Carolina, that did the exact same thing, that child in South Carolina would be treated as a juvenile, and his record would remain confidential. In North Carolina, that record would stick with him when he applied for college, when he applied for financial aid, when he applied for housing at college or in the future, when he applied for a job in the future, he would have to check that box that he had a criminal record in the past. And in doing so, automatically discriminated against him versus other kids from other states that didn't have to do that same process. So juvenile employability is a big part of this. Parental involvement is a big part. Parents must be involved in the juvenile justice system. I'm really glad that we're here today at DSS, because DSS is a big part of this conversation. And how is this going to occur moving forward? But we know that parents need to be involved with young people. If you have a 16 or 17-year-old, if they run away from your house, you're responsible. But if they get arrested and put in jail, all suddenly you're not responsible because that's a criminal event. That doesn't make any sense. And so what we're saying is that parents should be involved. If they're 16 or 17 years old, the parents should be involved in the process, and the juvenile justice system requires that to occur. The folks that work in the juvenile justice system are trained to work with this population. That's what they do every day. Module's great staff that are here in Cumberland County, the great staff over at the detention center, these are the people they work with every day. They're trained to work with adolescents. And adolescents are different than adults. And we should treat them differently, and we should specialize our treatment towards them differently. And that's really what we're saying here, is that we've got professionals in the juvenile justice system that do that every day. And that's a real good reason why we need to keep this population in the juvenile justice system. Other states have had very positive experiences. When we were looking at raising the age in the state of North Carolina, we specifically went out and looked at the states that had just recently raised their age. So we went to Texas, Illinois, and Connecticut, and looked at those three states. Yes, Texas beat us to the punch. All right? In Texas, 5 years ago, they raised the age. When they raised the age, they went back and looked at the success of it 2 years later, and what did they find? They found that recidivism for juveniles that stayed in the juvenile justice system because of raised the age dropped by 20%. 20% reduction in recidivism by keeping those juveniles in the juvenile justice system versus putting them in the adult system. They actually went back and included more juveniles the next year because it had been so successful. Same thing was true in Illinois, and same thing was true in Connecticut. They all found extremely positive experiences by raising the age in those jurisdictions. The brain science supports it. I'll get to that in just a second. And then the U.S. Supreme Court has made 3 major decisions over the last 5 years that basically says you can't treat someone under the age of 18 the same way that you treat someone over the age of 18. And so this law helps to bring us more in compliance with those rulings. There's more that the state needs to do to address some of the findings that those court cases have said, but these definitely push us down that road. So here are the recidivism rates that I was talking about. As I said, this has been studied. If there's another policy in the state of North Carolina that's been studied more than this, I don't know what it is. There has been at least 15 different studies done on raise the age in the state of North Carolina. These are just 2 of them, and each of them show that the reduction in recidivism by keeping juveniles in the juvenile justice system is very significant and something that the state of North Carolina should do. And part of those studies also showed that there would be a cost savings to the state of North Carolina by doing so. Now you may be thinking, how are you going to get cost savings? Because you're going to have to hire more court counselors. You're going to have to put in place more community-based services. You're going to have to put in place additional youth development centers and serve additional kids in youth development centers. All of that's true. But think about a child that's saved by keeping them in the juvenile justice system. Reduce incarceration, a tax-paying citizen, a kid that has a high school diploma. Think about all the positive benefits that that child gets by staying in the juvenile justice system versus being thrusted into the adult system. And that's where those cost savings start to come from. This is real dollars, meaning actual savings to the state budget each year. When you look at actual intrinsic benefits, the intrinsic benefits that a kid gets from staying in the juvenile justice system, that number grows to over $50 million. So those aren't exact actual tax dollars, those are actual benefits to society as a whole. And this is on a recurring basis every year. And these were independent studies done not by people even in North Carolina. These were people that we brought into the state to look at how this would affect our public policy moving forward. So when we talk about juveniles are different than adults, what is the first thing to understand? If you haven't heard, juvenile brains don't fully develop. In young males, it takes until they're about 25 years old. In young females, it's around 23 years old. And the last part of the brain that fully develops in young males is that part of the brain that we call the frontal cortex. And that part of the brain is the part of the brain that says, don't do this, it's stupid. Okay? Excuse me. Getting choked up is so important. But when we're talking about that, what we're saying is that it's not that kids don't know the difference between right and wrong. It's that they don't take the time to stop and think about it. And that's the difference between juveniles and adults, is they don't have that impulse control. I always say they're kind of like a sports car. All right? They got this brand new, beautiful body, wonderful looking car, and they got a great accelerator. They can go from 0 to 60 in no time. The problem is they forgot to put the brake on it. The brake is the frontal cortex. It's that part of the brain that says, stop, this is stupid. And that's what we're talking about when we're talking about impulsivity. Sensation-seeking behavior. What is sensation-seeking behavior? For my folks that have been a school resource officer before or have been in law enforcement, if you've ever worked at a school before, when there's a fight at a school, all the kids run away, right? No. They all run towards it, right? They're like a moth to a flame, right? Why do they do that? Sensation-seeking behavior. They look for things that give them an adrenaline rush. All right? If you were in law enforcement when you were younger, you may have remembered how you felt about being in law enforcement when you were younger. When you're 20 years old, you wanted to be the first one on scene all the time. Now you say, oh, well, maybe John can get there first. Things change over time. We don't seek that adrenaline rush as much as we used to when we were young people. That's a normal part of human development. And so when we're talking about sensation-seeking behavior, it's important to understand this in the context of why we want to change the age. For years, we thought we could just scare juveniles straight. And sometimes the scarier you make it, the more compelling you're making it for them to try it. You're almost daring them to try it. Let me see if I can do it. Let me see if I can get away with it. And that's what we're talking about when we're talking about sensation-seeking behavior. What also plays into that is their ability to understand risk. Look at this chart here. This is really important. When you have a 16 or 17-year-old in your house, just understand they do not see risk like you do. All right? If you drive in a car with them, they're driving for the first time, understand they don't perceive the risk like you do. All right? When you're stomping on your imaginary brake, they don't get it. All right? 16 or 17-year-olds are more willing to take on more risk than any other time in your life. And that's a normal part of human development. If they did not do this, they would live in your basement for the rest of your life. Because you want them to take a risk. You want them to get ready for independent living. You want them to go to college. You want them to go get a job on their own. But if they're not willing to take on that huge risk, I mean, can you think of anything more risky than moving out of your parents' house? This is a huge risk that they're taking, and we want them to do that. But at the same time, it's important for us to understand that they are willing to take these risks on and don't understand how it affects them long term, what the future outcomes of that will be. Same thing here with this is the perception of it. They perceive it differently than us. So the first slide kind of shows you their willingness to take on risk. And the second one is they don't even see the risk like you do. Most teenagers think they're invincible. If you don't believe me, go on the internet tonight and Google Tide Pods and teenagers. All right, you and I would never put a Tide Pod in our mouth. But they don't perceive the risk of putting poison in their mouth just so they can get a couple hits on the internet. It's a very different way of seeing the world when you don't perceive risk like you and I do. Future outcomes, what are we talking about here? Future orientation is about them thinking about something more than 15 minutes down the road. And for teenagers, we know that's difficult for them to do. When young people, when I go into our facilities, I ask our young people often, what do you want to be when you grow up? And they kind of look at you like, what? I don't know if anybody's ever asked me that question. Because there's an expectation in the house that they come from a lot of times that they're not going to do much. When we talk about future orientation, when I ask those young people that question, the three most popular answers I get are, I don't know, I'm going to be an entertainer, or I'm going to be an athlete. And then you go watch them on the basketball court and they can't even dribble the basketball. But they're going to be a professional NBA player, right? They don't have future orientation. They don't understand how their behaviors today affect them, what's going to happen to them 10 years down the road. And this is really important when we think about the criminal justice system. Think about that 16-year-old that's getting arrested tonight because of something stupid they did at school. Let's say they got in a fight at school, they got arrested for it. How is that handled in the criminal justice system? They get arrested, they might get a citation, they might get sent actually down to jail, but if they go to jail, they're probably going to bond out pretty quickly. There's going to be probably a very small fine, that's a bond that's set on that individual. And probably in 1, 2, 3 months, they'll come back to trial. They'll come back to court. Most often, they'll plea bargain. And that plea bargain is often agreeing that, yes, I did get in the fight at school. And my consequence often is unsupervised probation. Right? In the adult system, a lot of kids in that first-time offender is going to get unsupervised probation. Why is this important when we're talking about the criminal justice system? In the juvenile justice system, that same kid would come into the court counselor's office and we would have had a conversation. We would have done a risk and needs assessment. We would have looked at what is going on with this child and this child's family and trying to determine what is the best route of treatment for this child moving forward. Did we have to wait 3 months to go to court to do any of those things? Absolutely not. We do it right away. We get involved with that child right away so we can make immediate changes in their life. I always say this is like, if you're a parent and your child acts out tonight, walking up to your child and saying, in 3 months, you and I are going to have a conversation about this. What do you think is going to happen in those 3 months? To their behavior? Are they going to change their behavior? And so that's what we're talking about with future orientations. Same thing with the delayed gratification, same idea. And then the last one is that juveniles are heavily influenced by their peers. Duh, right? If you've had a kid, you know that your kids are heavily influenced by other kids around them. And well, why do I put this in there? Because it's really important about what causes juveniles to make decisions. The influencers around them are their friends. If you ever are brave like me and decide to have a sleepover with your 12 or 13-year-old and allow them to bring 4 or 5 other girls into the house, you know that you're a perfectly rational, normal child. When those other 4 or 5 other girls get in the house, their brains all go out the window for some reason. It's because they're heavily influenced by their peers. So when we're talking about that, how does this play a role in what we're talking about? A lot of people have said that they're concerned with raise the age that 16 or 17-year-olds will be used by older adults to do gang activity for them, or run guns for them, or run drugs for them. Is that possible? Absolutely. Is it probable? Absolutely. You know why I know that it will probably happen? Because it happens today. 16 or 17-year-olds are used all the time today by adults to do those stupid things. All right, because 16 or 17-year-olds don't make good decisions and they're heavily influenced by their peers. The question is, how do we want to change that behavior? Do we want to go after the 16 or 17-year-old and throw the book at them and make sure that they can never see the light of day again? Or do we want to go after the 25-year-old or 30-year-old that convinced that 16 or 17-year-old to do that really stupid thing? I think we need to go after the older person and really try to influence and change that behavior, go to the root cause of the problem that's influencing that 16 or 17-year-old to do that behavior. Now, don't walk away saying, well, Billy said you don't have to hold the 16 or 17-year-old accountable. I didn't say that. We absolutely want to still hold 16 or 17-year-olds accountable. What I'm saying is that we also need to address the root cause of the problem, which is that adult that's influencing that child to make a bad decision. A couple other myths that you might not know about the juvenile justice system is that you know that most juvenile crime is for minor crimes. Most juvenile crime committed in the state of North Carolina are for minor crimes. What do I mean by that? If you look at the yellow bar up there, that's status offenses. What are status offenses? They're only crimes you can commit as a juvenile. Running away from home, being truant from school. Those are status offenses. All right? 9% of all juvenile crime that was committed in the state of North Carolina last year were for crimes that you can't even commit as an adult. You don't even have the ability to do it. All right? So 9% were for those types of crimes. Then 63% were for misdemeanors. 63% of juvenile crime committed in the state of North Carolina last year were for misdemeanors. So if you add the status offenses and the misdemeanors up, you're up to almost 3/4 of all juvenile crime in the state of North Carolina last year were for status offenses or misdemeanors. Then you got that blue category right there, which it says serious on it. Those are the low-level felonies. All right? So then there is this quarter of the population that commit more serious crimes that we need to deal with and really focus on, and that's that 25% that fall in the blue category. But the red category at the top, that's the really serious offenses. Those are the A through E felonies. But I think it's important for people to understand those A through E felonies make up only 3% of the population. Only 3% of the population that comes in through the juvenile justice system are coming in for A through E felonies. Now, these are what they were actually charged with. This is not what they pled to. This is what they actually entered the system with being charged with. So this is really important as we go through this discussion about raise the age, because when we're talking about this, we're talking about one of the populations is that A through E population. For years, people have said, you can't raise the age because we don't want to put a bunch of juvenile murderers in the juvenile justice system. First of all, understand that's a very small part of the population, an extremely small part of the population, when you're talking about something as serious as murder. But even when you take the full category of A through E felonies, it's still a very small portion of the population. In fact, last year in the state of North Carolina, we looked at all the 16 or 17-year-olds, and only 327 incidents occurred, A through E incidents occurred by 16 or 17-year-olds in the state of North Carolina. All right? It's a small population, and what we decided at the very beginning this time was we're just going to take them off the plate. We're not even talk about that population because we're going to automatically keep them in the adult system. So that A through E population is going to stay in the adult system instead of the juvenile justice system. And we actually added to that. The General Assembly decided to make that even a bigger category and made it A through G. So the A through G felonies will stay in the adult system. So it's only the H and I felonies and the misdemeanors that will remain in the juvenile justice system. A couple other things you may not know about the juvenile justice system is that juvenile crime is going down. For 10 straight years in the state of North Carolina, juvenile crime has actually dropped in our state. This is really positive news. It didn't happen because of something I did. It happened because of something you all did. This room, the people in this room, the mental health professionals, the school professionals, the people working in juvenile justice, the people working in our DSS system, you guys were the ones that caused these numbers to drop. You decided as a community, we're going to wrap around these kids and protect them and make sure that they're successful in our local communities. That's what's helped drive these numbers down, and it's something we should be proud of in the state of North Carolina, that we've seen this drop in juvenile crime. You see the blue bars here are the actual number of complaints coming into the system. That would be equivalent to adult arrest. The red bar is the number of status offenses, and the green line actually shows you the rate of juvenile crime in the state of North Carolina. That's the number of complaints being filed per 1,000 juveniles in our state. This shows you Cumberland County's numbers. So look at the numbers. This is just over the last 5 years. You've gone from 1,600 complaints in Cumberland County to just over 1,000 last year. So that's a 600 number of complaints dropped in your county over that time period. That's almost 1/3. A 1/3 drop in the number of complaints being filed in Cumberland County. And so that is very impressive and something that you should be really excited about in your local communities. We've got this data on a spreadsheet that looks like this in your packet. And it lays out all this information that I'm about to go over as far as the school-based events and also the detention and YDC numbers. And I'll point back to it as we go to each of those numbers. This next slide shows you the school-based offenses. What are school-based offenses? They're offenses that occur on school campuses, on a school bus, at a school bus stop, or at a school-sanctioned event. Those are the 4 areas that a school-based offense can occur. Last year in the state of North Carolina, 42% of all juvenile complaints filed in the state of North Carolina were filed on school campuses or in one of those other 3 locations, the school bus stop, or a school-sanctioned event. 42% of all juvenile complaints. It is the most likely place in the state of North Carolina that you will have a juvenile complaint taken out on you is at school. All right? We should be wondering, why is that? I mean, we would want school to be a protective factor for our children. We want them, obviously, to be safe there, but we also want them to make sure that they can be successful by going to school. Right now, what we see is that population, that percentage has remained pretty steady across the last few years. And let's look at what's going on in Cumberland County. Y'all have had some tremendous progress in this area. So if you look at the data here from 2012, about 50% of your juvenile complaints were coming from schools. Last year, that dropped down to 29% of all juvenile complaints were coming from school campuses. So there's been you're way below the state average now on these juvenile complaints coming from schools, and have made tremendous progress. I don't know what you did in 2014, but we want to know what it was so we can replicate it. Because that is obviously something really important changed in the system in this area in 2014. A big part of this legislation that on raising the age also included a component called the School Justice Partnership. What is the School Justice Partnership? It says, let's look at those behaviors that occur at school campuses and determine whether or not they're school discipline problems or they're criminal justice problems. Right? Are we going to treat them as school discipline problems, or are we going to treat them as a criminal justice problem? I'll give you a good example. Of that 42% of juvenile complaints filed last year in the state of North Carolina on school campuses, the top 2 offenses were simple affray and disorderly conduct. What is simple affray? A fight. A small fight. That's why it's called simple. All right? A small fight where nobody got hurt. If somebody got hurt, they would have been charged with assault. All right? So it's a small fight where nobody got hurt. That's what a simple affray is. Disorderly conduct. What is disorderly conduct? You disturb the educational environment for more than 2 students. All right? If you disturb the educational environment for more than 2 students, you can be charged with disorderly conduct. All right? And so that could range from a big thing that happened at that school campus to something pretty small that happened at that school campus. So that's a big category that a lot of things fall into in that disorderly conduct. But I want you to think back to when you were a kid in school. If you got into a small fight at school where nobody got hurt, did somebody get arrested for that? No. Now, I'm not saying there wasn't an intervention. There was an intervention. All right, you went down to the principal's office and there was an intervention with the principal, right? And part of that intervention was picking up the phone and calling mom and dad. And I can guarantee you, whatever intervention the principal had at my house, the intervention at home was going to be far greater than the intervention at school. Something's changed in our society where we've decided instead of having that intervention in the principal office, we want to now have it in the district attorney's office. What changed? Why have we made that choice in our society to make these criminal justice problems instead of school discipline problems? And how we want to handle them. And the problem is that if you arrest a child, there automatically sets up an adversarial relationship. That child's family is going to try to defend their child so they don't have a criminal record moving forward. So they're automatically going to be defensive. They're automatically going to be trying to figure out, how do I get my child out of this thing instead of take accountability for this action. And those are the exact opposite actions that we want to have happen. We want the parents to be involved and be part of the process and engaged in actually what the discipline is of their child moving forward. So that's what the School Justice Partnership is really looking at, is how do we change those dynamics. And you guys are doing a good job here in Cumberland County. That doesn't mean that there isn't more progress that can be made. How this will be handled is a memo of understanding between the law enforcement agencies, the schools, the DA's office, the Chief District Judge, and most of the districts across the state are the facilitators of this conversation. And coming up with a memo of understanding about what things are we going to treat as school discipline problems and what things we're going to treat as criminal justice problems. It also gives school resource officers a good feeling knowing that how these things should be treated. I know when I used to train school resource officers down at the Justice Academy for many years, this was the #1 question that I got asked is, when do I get involved? When does this become a criminal justice issue that I, as a school resource officer, should get involved in, and when should I not be involved? What are those incidents where I should not get involved in? That's really what this School Justice Partnership is all about. One last big myth that you may think of the juvenile justice system is that most of the kids in the juvenile justice system are gang involved. Last year in the state of North Carolina, only less than 8% of juveniles coming into the juvenile justice system were gang involved. Less than 8%. Now by the time that juvenile moved to a detention center or a youth development center, their likelihood of being involved in a gang increased greatly. In fact, by the time they got to a youth development center, 50% of juveniles in that youth development center were gang involved. So from the front end of the system, only 8%, but by the time they got to the deep end of the system, 50% were gang involved. Why do I point that out to you? One of the big reasons why juvenile justice for years has been pushing back on trying to reduce the number of kids in juvenile detention is because most of the kids that end up in juvenile detention are high risk and high needs. Right? They're very high risk and very high needs. If you take a low risk kid with low needs and you throw them into a detention center for 14 days with a high risk, high needs kids that are all surrounding them, guess what? There's a contagion effect. They start to relate with other kids that are now high risk and high needs. Right? And have much more criminal involvement than they did. So we try to reduce the involvement of low-risk kids if there's another way to serve that individual. For example, putting them on electronic monitoring. Putting a child on electronic monitoring costs the state $5 a day. Putting a kid in juvenile detention costs the state $244 a day. So what we want to look at is what is the best alternative for that child and the best way to serve them moving forward. This shows you your numbers in Cumberland County, and y'all done an awesome job at reducing detention admissions in the county. So 5 years ago, there were 412 kids in detention admissions. Last year, that number dropped to 180 juveniles in the county that were detained in juvenile detention. So that's a huge drop in that population. You can see that's also kind of mirrored on the state level. We've seen a huge drop in juvenile detention across the state. 67% reduction in juvenile detention. A couple of reasons why this is important. One, the one I just told you about, that we want to make sure that detention is reserved for those kids that need to be there, that cause a public safety risk or a risk to themselves. But two, it saves the county money. So my county commissioner that was talking to me earlier, was asking me, when am I going to help pay for the office space for my court counselors? I already did, right here. When we reduce this population, that saves you $122 a day for each of those kids that weren't put in detention. All right? So by reducing it by 200 kids times 14 days times $122, that pays for some pretty good offices. Or some at-risk programming, or for some programming for our school folks to do prevention with, or for our JCPCs to do more programming with. Those dollars we're asking county commissioners to reinvest back into your local community to prevent kids from coming deeper into the system. This is your Youth Development Center numbers, and again, we've seen a reduction in that population in the state and on the county level from 19 to 14. And you can see the overall population in the state has gone down significantly. Youth Development Center is really expensive. So Youth Development Center is about $130,000 a year to put a kid in a Youth Development Center. All right? It is the most expensive, most intensive intervention that we have available for us in juvenile justice. Why is it so expensive? Last year, 99% of all juveniles that came into a YDC had a mental health diagnosis. Over 50% of them had 5 or more mental health diagnoses. The average kid that came into a youth development center last year was 5 years behind on reading and 4 years behind on math. You're talking about intensive interventions that have to be done with that population in order for them to have a chance to be successful when they get out. But what I also say to my new superintendent over here is, imagine if you were able to take that $130,000 and put it on that child and leave them in your local community. What could the school system do with $130,000 to work with that child in that local community? What services could you wrap around them? What things could you do in your local community to make sure that they are successful and get a good education? And that's the calculus that we have to make. Obviously, some kids need to go for public safety reasons, and we want to make sure that we send those kids. But that's why we reserve it for those kids that are most intensive in the system. The last slide I want to show you as far as numbers is this is, I think, is really amazing. If you look at the number of 16 or 17-year-olds that are served under any form of adult supervision. Remember, in the state of North Carolina right now, as a 16 or 17-year-old, you're going to be under adult supervision if you commit a crime. So this chart shows you, back in 2000, we had over 8,600 16 or 17-year-olds under any form of adult supervision. Last year in the state of North Carolina, we only had 2,700 juveniles under any form of adult supervision, the 16 or 17-year-olds under any form of adult supervision. That dropped from 2000 to last year. That's a huge drop of over 60% over that time period. Two important things that I want to point out here. Number one, when we first started considering raise the age back in 2000, when the Juvenile Justice Reform Act was passed, we would have had to bring 8,600 additional juveniles into the juvenile justice system, and that would have been more than double the population we currently have on supervision today. But today, if we just take the population that are under adult supervision and assume they'll be under juvenile supervision, you're talking about only 2,700 additional juveniles. That's a huge difference. And that's why raising the age today makes a lot more financial sense than it did back in 2000. But it also gives us a lot of hope, because what does this tell us? The investment we're making in the juvenile justice system is paying off in the adult system. The investment that we're making in the juvenile justice system is paying off in the adult system. How can I say that? Because we know our recidivism rates are dropping in the juvenile justice system, and it's now showing up for the first time in the adult system. You're seeing fewer and fewer 16, 17, 18, and 19-year-olds being charged with adult crimes than have happened in this state in over 40 years. Something's changing. The dynamics are changing in the state, and it's because I think we changed as a state about how we treat juveniles, and we do a much better job than we did 20 or 30 years ago at getting results. When I first started in juvenile justice, a kid that went into a youth development center had an 81% chance of recidivating. I mean, that he had 81% of the time they were coming back. Today, that's dropped to 41%. We cut it in half. All right. We've also done the same thing in the community. We've almost cut in half the recidivism rates for kids on community-based services in our local communities because we're using more evidence-based practices than we ever have before with working with this population and are getting better results. So what is this going to look like as far as the new population coming into the system? This chart shows you what we expect over time as far as the new population. This is statewide. So in that first month of implementation, you see 564 additional juveniles will come into the system in that December of 2019. All right, and each month after that, the red bar shows you the additional number of juveniles we think will enter the system. And this mirrors the normal trend that we see in juvenile justice. As you can see, there's a dip right there in the middle. What happens right there in the middle? School's out. School's out, and our number of complaints drop tremendously when that happens. When the kids go home for the summer, our numbers go down for the summer also. The other big time that it drops is right at Christmas. I'm not quite sure why at Christmas. I know they're out of school for a little while at Christmas time, but I think law enforcement are just, maybe they're in a jolly mood then and say, well, we're just going to let them go home. I don't know. But we do see that drop at Christmas time and in the middle of the summer, those number of complaints in the system. So let's look at Cumberland County. What can we expect in Cumberland County? What did we do here? Well, we took the number of charges that were filed in Cumberland County last year against 16 or 17-year-olds. All right? So that's that first column that you see on the far side over here. So that's that 726 number that you see right there. That 726 is the total number of charges filed on any 16 or 17-year-old in Cumberland County last year, for any reason, except for we excluded motor vehicle violations. And we'll come back to that in a second, and why we did that. So you can see that that number is 726. On the far side, we have this estimate of 281 as far as new juveniles that will come into the system. How did we get to that 281? We divided the 726 by 2.4. Why did we do that? Because when a juvenile gets arrested, do they normally get charged with just one crime? No. What we found was on average, when a juvenile gets arrested, just like an adult gets arrested, they normally get charged with 2 or 3 crimes, or 4 or 5. All right? And the average for juveniles was 2.4. 2.4 crimes for every incident that occurs they get charged with. And so we divided the number of charges filed by 2.4, and that got us the number on the far side, which is 281 additional juveniles would be coming into the system that were once served in the adult system. The middle category shows you the estimated number of new juvenile court counselors. So my county commissioners and my county manager, this is where you guys come in. We need additional space for probably 6 new juvenile court counselors. 6 additional juvenile court counselors to handle the new caseload that's coming into the system. Now when I say we need the office space for them, keep in mind we do provide some of the other stuff. We provide the computer, the telephone, the car, their salary, and everything else that's associated with that position. The one thing that we ask the county for is the office space. And for that office space, in turn, you get a lean, mean, fighting delinquency machine. All right? And so I think it's a pretty good deal for the counties to get those positions. So that's 6 additional juvenile court counselors that we are expecting. Now that's an estimation. Could it be 7? Could it be 5? Absolutely it could. Once we get into it, we'll get a better understanding of exactly where we're at. But we wanted to give you guys the closest estimation that we could come up with based off of the numbers that we see right now. Now what produced that number in the middle? You're seeing just 2 of the factors that go into that. We also looked at diversion rates. We looked at the number of kids, the types of supervisions that kids were put under, the number of intakes that were involved in the system. But these were the most important numbers we thought for you guys to look at as stakeholders moving forward. For our Chief District Judge, you can use this information to help you determine how much more court space you're going to need. So you're talking about 281 additional kids coming into the system. Now, not every single one of those kids is going to make it to court. Some are going to get diverted, and we can give you that exact breakdown and show you where that, how that falls. But then divide that by 12 months, and you can kind of have an idea of how many additional cases that you're looking at each month coming into the system. So let's look at the what. What was actually included in the legislation? Number one, as I said before, it does not go into effect until December 1st of 2019. That's important. I know the day that this passed, we actually had 3 sheriffs call me up and say, Mr. Laster, when are you going to come and get these 16 or 17-year-olds out of my jail? All right? That's not how it works. It does not go into effect until December 1st, 2019. And if they're in your jail on November 31st of 2019, guess what? They're staying in your jail. All right? We only take the new ones. There's a couple of major things to understand here. Number one, what did this change? It changed the definition of what a juvenile delinquent is. It did not change the definition of what a juvenile is. In the state of North Carolina, a juvenile has been defined as anyone under the age of 18 for 30 years. All right? Anyone under the age of 18 is the definition of juvenile of what a juvenile is. They actually wrote a specific separate definition for juvenile delinquent to exclude 16 or 17-year-olds for being juvenile delinquents. All right? So if you went into civil court and you were under the age of 18, you would have been treated as a juvenile. If you went into family court, you would have been treated as a juvenile. It was only in criminal court or juvenile court that, for criminal offenses that you would have been considered an adult for those 16 or 17-year-olds. So we changed the definition of what a juvenile delinquent was. There are some exclusions. The first and most important one is motor vehicle violations. Motor vehicle violations are excluded. Why did we do that? A couple of reasons. Number one, who do you think is most likely to get a ticket in our society today? A 16-year-old male. All right? When we looked at the 16 or 17-year-olds and how many tickets were written on just 16 or 17-year-olds in our state last year, it was over 20,000 tickets were written to just 16 or 17-year-olds last year. If we took all 20,000 of those and threw them into the juvenile justice system, it would have overwhelmed the juvenile justice system. So we left those in the adult system, and they will be handled just like they're handled today. So if you're writing a speeding ticket for a 16 or 17-year-old, you will do it exactly how you do it today. You write that exact same citation. They'll go to the exact same court that they used to go to, and it will be handled in the exact same way. The other big reason why we didn't exclude 16 or 17-year-olds the exclusion was put in for 16 or 17-year-olds for motor vehicle violations is because the insurance companies didn't want your child's driving record to be confidential. Why? They wanted to raise your rate when your child got a speeding ticket. And if your child's driving record was confidential, they would not be able to do that. Now that their records will remain for public view, they will be able to raise your rate. And so they were obviously against having those motor vehicle violations in the juvenile justice system. And it turns out they have a pretty good lobbyist too. Got to meet them a couple times. So what is a motor vehicle violation? The legislation did not specifically define what a motor vehicle violation was. So we have gone back and rewritten the definition and are submitting it back to the General Assembly so that they can include that into what we're talking about. And we're going to define it as anything that is a Chapter 20 infraction or misdemeanor. Any Chapter 20 infractions or misdemeanors. All right? It would not include Chapter 20 felonies. Those would remain in juvenile court. There's very few of those, but there are a couple of them. For example, eluding. There's an eluding law enforcement officer by speeding. There's a misdemeanor version, and there's a felony version of that. So the felony version would stay in juvenile court because that has criminal implication tied to it, and the misdemeanor version would remain in adult court. And so these are a couple of the other examples of things that we were considering and trying to figure out how to make this work. And you can see those listed here. Because there are several ones that don't fall in Chapter 20, but still have that word motor vehicle in the actual criminal offense. So we wanted to make sure that we went back and defined it clearly for law enforcement and our DAs and our defense attorneys across the state, so they understood exactly what it was going to include. And so that change will hopefully be included in the legislation by the end of next July. The next important part to understand is that the maximum age was also increased. What is the maximum age that we're talking about here? It's not the maximum age that you can be charged at. This is the length of time that we can keep you under juvenile supervision. So right now, juvenile supervision has to end for most crimes at age 18. This increases the length of time we can keep you under supervision. So if you're 16 years old when you get charged, we can keep you through your 19th birthday. And if you are 17 when you're charged, we can keep you through your 20th birthday. This basically allows the juvenile court counselor to have 3 full years of supervision with that juvenile before they can be released. Now there's also indeterminate jurisdiction, and that allows us to keep some kids until they're 21 years old. That stayed in place. That statute did not change, so that's still the law of the land. This is just for those other crimes. Now keep in mind, so if you're a community-based program provider, you're thinking, okay, I'm going to have a lot of 17, 18, 19, and 20-year-olds also. The crimes that are left in the juvenile justice system aren't typically those crimes that you stay under supervision for a full 3 years unless you don't do well. All right? And so it would be unusual that a kid would stay for 3 full years, but this allows for that possibility to occur. So the other things that are excluded are the A through G felonies. As I told you, we recommended A through E. When the Chief Justice had his Commission on Law and Justice across the state of North Carolina, the recommendation that came out of that commission, and also out of the Substance Abuse and Mental Health task force that the governor put together, they both recommended excluding A through E felonies, but the legislator decided to pump that up a little more to A through G. Why A through G? It's called compromise. There were several different bills that were introduced. One only excluded misdemeanors from it. One that allowed every juvenile to stay in the juvenile justice system. So the compromise that was landed on was A through G felonies would stay in the adult system. But it's not automatic to start out with. It's automatic once indictment or probable cause is found. What does that mean? So that means that even for the A through G's, they start in juvenile court. That means if you're a law enforcement officer and you arrest a kid for an A through G felony, it would still go through the juvenile process until that kid is indicted or probable cause is found for them having committed that crime. Why did we do that? We did that because we often know that what a child gets charged with on a Friday night is not what they end up getting indicted of a week later. We wanted to make sure before we rang the bell of this is an adult now, because there's no way to unring that bell, that we gave them the protections of the juvenile justice system until that indictment or probable cause came down. And so that's why this procedure was put in place, is to protect against that, because we know if you get charged with an A through G and it was automatically based off the charge that you went to the adult system, your picture would be on the front page of the paper, you would be on the front of the newscast that evening, and there would be no way to unring that bell. This allows for those protections to be put in place until we can figure out exactly what happened in that incident and really figure out what we want to end up charging that juvenile with moving forward. And if it is indicted or probable cause is found and it is an A through G, then it would then shift to the adult system. What about the H through I felonies? The H through I, the H and I felonies can also be transferred to adult court. All right? So basically what this law says is that you can transfer any juvenile to adult court. The A through G's are just automatic once you have probable cause or indictment. The H and I's require a judicial review. That means that the judge will review the case after being petitioned by the prosecutor to move it to adult court, and if there is an agreement on that, then that case could be then pushed up to adult court also. So all felonies can be transferred. The A through G's are just the automatic ones. So what does this mean for our prosecutors and our juvenile court counselors, and what will this indictment process look like? The first thing to know is that the current statute says that you only have 15 days to get us an indictment or a probable cause hearing. And that's in the current statute as it is today, that those indictments or probable cause hearings are supposed to happen within 15 days. We are looking at currently changing that to give you more time to really figure out what the facts of the case are. And we're debating about how long we should extend that process. Should it be 30 days, 60 days, 90 days? What would be an appropriate length of time to allow for that indictment process to make sure that we're doing the right thing in serving that juvenile in the right court? So we're looking at that now, but the current statute says you only have 15 days. The other thing to note is that, again, the process will start with the juvenile court counselor. They will do the risk and needs assessment on that child just like they do on any other child, and handle that process just like they do currently. They could choose in those cases, just like they do now, to look at all the different options that are available for juveniles pre-trial, and all those available options for juvenile court would be available to them. What about confinement? So when we first started this process, our feeling on this was that once that child had been transferred to adult court, then that child would be transferred to an adult facility. All right? That is not how the current statute reads, though. The current statute says until a juvenile is actually sentenced, convicted and sentenced, they will remain in a juvenile facility. So the current statute says they must stay in a juvenile confinement facility until they're actually convicted and sentenced. I will tell you that my impression at first was that, okay, we're just going to allow them, we'll change the statute, we'll allow these transferees to go back to adult jails. Then I got a letter from almost 90, I think it was 95 or 97 of all the sheriffs across the state of North Carolina. They said, Mr. Lasser, don't do that. We don't want them. You keep them. And so we have been trying to figure out since that point how we can serve even those transferees in juvenile detention facilities. And we are working on actually establishing what we would call a transfer facility or a bound-over facility for that population. This greatly increases the number of beds that we will need to have available so that we can serve that population. So for example, I'm working with Mecklenburg County. They have a facility down there called Jail North. It has 123 beds in it. And it only serves 16 or 17-year-olds in that part of the facility right now. We are looking at just transferring that facility over to a juvenile detention facility moving forward. We're doing that in several other jurisdictions across the state, such as Wayne County, we'll meet with Hyde County, Madison County. We're trying to find facilities across the state where we can house this transfer population, where they can meet the guidelines of juvenile detention. So other parts that were included in the legislation, there was a gang suppression part of the legislation. That gang suppression part said that every juvenile that comes into the juvenile justice system must get a full gang assessment. So that will be part of our process starting on December 1st of 2019. Every juvenile that comes into the juvenile justice system will get a full gang assessment that will be similar to what's done on the adult side or in GangNet right now. And we will track that information, and we'll use that information to determine what types of services, what types of programs, what type of housing to put that juvenile in the future. The second part of that is the gang suppression part, which says if you get adjudicated, which would be the equivalent on the adult side to being convicted of a gang-related crime, your disposition level must be increased by at least one level. right? That may not sound like a big deal if you don't know much about juvenile justice, but there are only 3 levels in juvenile justice. So one full increase in level is a pretty big deal, all right? It means that if you are a level 2 kid and you get adjudicated and disposed of a gang-related crime, now you're at least going to spend at least 6 months in a youth development center in confinement. So that is a big change to the statute. There's lots of questions still out there about what constitutes a gang-related crime and how you're going to prove it. So what is the burden of proof? How do we prove it moving forward? A good example of that is a kid breaks into your house, steals a loaf of bread, and how do you prove that was either a gang initiation or that he was just hungry, right? How are you going to prove that in a court of law? What's the burden of proof to actually prove that? And so I think this is going to be a difficult one to figure out, so we're working on what those standards will look like in the future. What I will say is just because on the gang assessment you were identified as being a gang member doesn't necessarily mean that the crime that you committed was a gang-related crime. Those two are not, they are mutually exclusive in the process. There are greater protections put in place for victims. And so this statute included a way for victims to appeal the decision of our juvenile court counselors. Juvenile court counselors, when they receive a complaint from law enforcement, have 3 choices. They can either approve that complaint as a petition to go to court, they can divert that case, or they can dismiss that case. If they choose to divert or dismiss that case, the victim now has the right to appeal that decision to the district attorney. And then the district attorney can decide whether to accept that appeal and approve the case for court or not. And so this has already gone into effect. It went into effect on October 1st of last year. And so I can tell you, I think we've had about 10 of these across the state so far. Not a huge number, but this is an additional right that was given to victims. Now this was a right that complainants are the people that originally filed the original complaint to the Juvenile Court Counseling Office, typically law enforcement. The complainant has had the right to do this since 1999, to file an appeal to the district attorney if they did not agree with the decision of the juvenile court counselor. This law simply extends that right beyond the law enforcement officer to the victim now. As part of that process, we also updated all our letters that we sent to victims to explain the process to them better, to make sure they understood what exactly was going on in the case. To the best of our ability, we can't tell a victim everything. If they're getting mental health services, we can't describe what those mental health services are, but we do describe the types of things that they would probably be in, so that the victim understands that the kid is receiving services. Law enforcement was also given more information under this statute. This has already gone into effect also, went into effect on October 1st of last year. The statute says that now the Juvenile Court Counseling Office can establish what's called a consultation log. What is a consultation log? A consultation log is any time law enforcement calls a juvenile court counselor and says, I've got a kid here, and I'm not quite sure what to do with them, we can track that now as a consultation that we've had with you in law enforcement. My best example of how this works is tonight in Fayetteville, little Billy's breaking into a shed. Law enforcement gets called, law enforcement shows up, lo and behold, they catch little Billy breaking into that shed. They take him into custody. He's 10 years old, he starts crying, he looks really remorseful, he looks scared to death. You think, oh man, I bet this child's never going to do this again. You walk over, you take him over to mom and dad who's right down the street. Mom and dad say, don't you worry, we're going to take care of this situation. No big deal here. We know how to make sure that he's going to get the discipline he needs. You decide as law enforcement, I'm probably just going to let this kid go. And let mom and dad handle the situation. Before you do that, you call the court counselor's office up and just say, is there anything I need to know about little Billy before I let him go home? And the court counselor's office says, no, we don't have anything on him, but I'm going to put down a consultation that you've called me on little Billy. The next night, little Billy's breaking into another shed, this time in Spring Hope. Now, there would be no way that Spring Hope Police Department would know that the night before he was breaking into a shed in Fayetteville. All right, and so when the law enforcement officer from Spring Hope calls up and says, like, "Hey, I got little Billy here. He's 10 years old. He's crying. He looks really remorseful. I think he really feels bad about what he did." We type in little Billy's name. Lo and behold, there he is. He did this exact same thing the night before. This might be a case where we need to get involved. All right. And so that's the purpose of the consultation log, is when you choose as law enforcement, and law enforcement chooses all the time to divert cases or not file charges in cases against juveniles. When you choose to do that, if you want to call our office and do a consultation on that juvenile, we can now track that record moving forward so that if in any time in the future that comes up, we can let you know that information. The second part of this is that any case that you are investigating as law enforcement, if you're thinking about filing a complaint on a juvenile, we can provide you information on that juvenile's past history with the juvenile court system. So we can tell you what they've been charged with in the past, how those cases ended up in the court, did they get dismissed, did they get disposed, what type of disposition, is the kid already on supervision. We can tell you that type of information. Now, we can't tell you everything we have in our file because some of those things are not things for us to give. So, for example, we can't give you his school records or his mental health records or those things, but we can give you their juvenile record. And so anytime that you're investigating a case where you're thinking about filing a complaint on a juvenile, we can provide that information to you. So what's going to happen when this happens? You'll call up the juvenile court counselor's office and you'll say, "Hey, I'm thinking about filing a complaint on little Billy." And if you're thinking about doing that, then we can look up their records. If you just call up and say, "Hey, I got little Billy here, not sure what to do with him," the juvenile court counselor is going to ask you, "Is this a case where you think you might file a complaint against little Billy?" If your answer is no, our answer is, "I can't tell you nothing." If your answer is yes, then we can say, "Yep, I can give you some information on that." All right? And so when you call up the court counselor's office, that's the question you're going to hear. And just know we have to get a positive, affirmative answer in that before we can provide that information. The second part is that becomes part of the juvenile's confidential record. If you choose to write that information down, you'll need to put it in a file in a juvenile in a confidential place in your law enforcement agency. You can't just share that information with anybody. JWAS is being updated. What is JWAS? It's the Administrative Office of the Courts database on juvenile records. And so this is different than what we keep in the juvenile justice system. We have a system called NC Join that has all the case notes and everything that we've done with a child. JWAS is simply the court record. What happened with that juvenile moving forward? It has abuse, neglect, dependency, and delinquency cases in it. In the past, these cases were only good. You could only look up a child within your own county. So if they did something in Cumberland County and in Harnett County, you wouldn't see the Harnett County file. All right? So we went back last year and provided 20,000 records to the Administrative Office of the Courts so they could tie those kids together. And so now they have an independent identification number to tie that child together. Why is this important? So that if you are looking up a child in Cumberland County that has just moved into your area but has lived 3 other places in the last 4 years, you can find out what the records are on that juvenile in those situations. This is for DAs, this is for defense attorneys. They can get this information, and they can also provide that information in certain cases to law enforcement. And so this will improve the way that you can look up those juveniles in the juvenile justice system in JWAS. I talked about the school justice partnership and how that's being set up. There's going to be a toolkit that goes out to school districts and chief district judges across the state to work on how do we establish these school justice partnerships. I heard this morning they delayed it a little bit more because they're getting additional input from school officials on how to make this work for them. And so that should be coming out in the next few months here. There's additional training coming for law enforcement. We've updated the BLET, the basic law enforcement training. We'll also be doing in-service trainings, web-based trainings for law enforcement on raise the age and how this works. We also want to develop a pamphlet for law enforcement to put in every patrol car in the state of North Carolina that walks them through how the juvenile process works. Because we know a lot more law enforcement are going to be working with juveniles moving forward, and we want to make sure that you have the information on how to access the system correctly. I told you about the Juvenile Jurisdiction Advisory Committee. There are 21 members of that Juvenile Jurisdiction Advisory Committee. They have been meeting and making recommendations on additional things that need to be done to the statute and thinking through additional resources that are needed. And so they've already made their first report on March 1st, and I'll walk you through a couple of those recommendations that they included in that. But they will make a report every January on additional recommendations. So if you've got additional recommendations, we want them, and we want to see if there are things that we want to try to incorporate into those recommendations moving forward. So a couple of things that we're working on, just so you have an idea. One is transportation. That was a big one from law enforcement they've asked us about. I know this has been an issue even in Cumberland County with how do we transport kids to and from court. We are working on developing transportation plans across the state. And if local law enforcement wants to help with transportation, we will gladly accept it, and we will reimburse you for your time to transport kids. But if you don't have the resources to transport those juveniles moving forward, then we will transport them moving forward, and we are hiring additional transportation teams to do that with across the state of North Carolina right now, and buying additional vans and vehicles to do that. We're looking at all these additional components that you see over here. We've already purchased land to build a new youth development center, and that process is underway right now. We are working on all the new hiring that we're going to be doing with new juvenile court counselors in the next year, the onboarding training, the IT needs, and really collaborating with our partners. How can we collaborate with DSS? How can we collaborate with the schools, with law enforcement on making this work in local communities and mental health in local communities to make this work? Are there going to be additional needs for mental health because of this change? Absolutely. Why is that? Juvenile justice screens every kid that walks in the front door for mental health problems. Every kid that comes in the front door, we do a screener on. So when you screen for something, guess what? You're more likely to find it. And so the reality is that, yes, there are going to be additional needs for mental health services at the local level for juveniles. Same thing is true with DSS. If a kid shows up for court and they're 16 or 17 years old right now, and their parents don't come, no big deal. They don't have to come. If they don't show up after December 1st to court with their kid, big deal. And so those are cases where DSS will probably have to get involved and be part of those conversations. And so we want to work with our partners and really think through what does that mean at a local level for these cases, and how can we support you, and what additional resources you may need to make that happen so we can make those recommendations back to the General Assembly. Hit a couple of these recommendations real quick, and then we're almost done with the presentation, and then we'll take a break and come back and take questions and recommendations. So the first question we got asked by the General Assembly, it was actually in the statute. It said, here's 11 additional crimes we want you to consider for automatic transfer to adult court. What does the Juvenile Jurisdiction Advisory Committee want to do with these particular cases? Our recommendation to the General Assembly was not to change anything. Leave the A through G's be the automatic transfers, and the H and I's be the possibility for transfer. There was already a protocol in place for H and I's to be transferred. There was no need to go through and pick out crimes that we just didn't like more than other crimes and decide that those were automatic transfers, because there was already a process in place to do that with. And we went back and looked at actually those particular crimes. There are only 63 kids across the whole state that were even convicted of those crimes last year. So why are we going to write a ton of new statutes just to handle 63 kids? That didn't make a lot of sense. The next one is the confinement issue that I was talking to you about earlier. So what the Sheriff's Association basically said to us was, If the kid is under 18 and they're being served in juvenile court, or they're a transfer from juvenile court that has not been sentenced and convicted yet, we want you to keep them in a juvenile facility. Why did they want us to do that? Because if they go to a jail, they have to still create that sight and sound separation in the jail for this population. They have to follow all the PREA guidelines in that jail for that population. So if we're taking most of the population and putting them in juvenile detention, they wanted us to take all of them. Because for them to have 1 or 2 16 or 17-year-olds in their jail, they'd have to have specially trained deputies or officers that worked in those facilities just to handle that population and meet all those guidelines. So we agreed to this recommendation that we would keep them while they're under 18, even if they've been transferred to adult court but have not been sentenced and convicted yet. We also agreed that we would do the transportation of those juveniles, that we would transport them from detention to court hearings and to other placements when it's needed, and we would take that burden off of local law enforcement, and so that was a recommendation that we made. Again, if you got a facility in Cumberland County and you've got a sheriff's department or a police department that wants to transport those kids because it makes sense to do that in your local area, we're all for that. We will reimburse you to do that moving forward. If you choose that you want the juvenile justice section to make those transports, we will do that. We want to have a conversation with you guys about what's the best way to handle that moving forward. Once they are convicted and sentenced of a crime under the age of 18 that was convicted in adult court, then at that point they can move to an adult correctional facility or a jail and be housed there, because the federal statute says once you've been convicted and sentenced as an adult, now you can be treated as an adult in any adult facility, and there wouldn't have to be sight and sound separation. So at that point we could transfer them to the adult jail. The other part that we said is even if they're pending trial still as a transferee in juvenile court, and they're still pending trial as a transferee to adult court, and they turn 18, at that point we would like to transfer them back to the jail also. Because if we don't, then we would have to do sight and sound separation on them in our own facilities. And that would be extremely resource intensive for us to do. So the sheriff's departments have agreed that they would be willing to do that. And so once they turn 18 in a juvenile detention center, we will transport them to their local jail and drop them off for you. And you can handle them from that point moving forward. The last one is that we want to do video conferencing between detention centers and our courts. In juvenile court, a kid has to go to court a lot more often than in adult court. The statute says in the first 5 days they must do a first appearance, and every 10 days after that they must come back to court when they're in secure custody. Even if everybody knows the outcome of the case beforehand, that kid's staying in juvenile detention, they still have to come every 10 days unless they waive their right to come to the court hearing. And so video conferencing would help us handle those cases more quickly and more efficiently than having to transport kids across the state and figure out how to do that. So we're going to work with the administrative office of the courts to figure out that process. Other question that the General Assembly asked us was, what about staggered entry or implementation? What if we just did 16-year-olds in 2019 and then came back 2 years later and did 17-year-olds in 2021? We said, if we're going to do it, let's do it all at once. It's just like I tell my kid when I pull the Band-Aid off of her, let's just do it all at one time and get it over with. Because if we have to do it 2 separate times, we'll have to come up with separate materials, separate training, more policy development in each of those different cases, change all the forms twice. It just doesn't make any sense to do that. And so we're recommending keep it how it is in the legislation and not do staggered entry. What about additional resources? These are the things that we asked for that you see listed here. So in the first year, we've asked for 65 additional court staff, juvenile court staff to be hired. That was included in the governor's budget. It was in our recommendation, and it was included in the legislative budget. So those positions will be hired next year, 65 additional positions for juvenile court counselors. We asked for expansion in JCPC funding. That was in our recommendations. It was in the governor's budget, but it was not included in the General Assembly's budget. And so we have gone back and asked if we can get that money put in for this year. It was not included in the original budget. We have gone back, and if there is a technical correction bill run, we have got interest that says that they may include that funding for this year. So we're still on the edge there. We might still have a chance. There's a couple rays of hope that we will get that additional JCPC money for that upcoming for the upcoming fiscal year. The reason why they did not include it for this year is they said, well, why do you need the money a year and a half in advance before the law changes? And I get, if you don't understand the process, why you would ask that question. But understanding it from a program perspective, from our program providers in here, you know you can't start a program in a month or 2 months. You got to hire people, you got to train people, you got to find a place or location to do that service out of. You got to change your policies and practices and procedures and make sure they're all up to date before you can handle this additional population. It's not something you can just do overnight. So after going back and explaining that to many of the legislative members, I feel like we've gained some momentum and they understand why we need that funding in the upcoming fiscal year. We did get the additional money also for capital so that we could go ahead and start building the new youth development center. And as I said, we've already done the purchase of the land there and are moving forward on that part of the project. On the non-recurring side, so for my county folks, just know we did get the non-recurring money to help pay for the office space, for the desk, the phones, the cars, and everything. That was included in the budget. So we do have all the non-recurring part of that money. IT would also be taken care of with this additional money. So we would be able to do all those things and help you guys as we're establishing those office spaces across the state. And that's what you see here is for that additional non-recurring money to put those in place. In the out years, what are we looking at as far as additional resources? And as I said, this year we're asking for $3.4 million for JCPC funding. In the final year, in 2021, we're asking for almost $16 million additional dollars in JCPC and community-based service funding. This is to provide residential placements, community service, restitution, all the services that we want to have in place as alternative dispositions across the state of North Carolina. Again, I've heard that people are very supportive of this and are wanting to give us this funding, and nothing is a guarantee, though, until it's put in writing. And so this is where we need you all to be advocates at the local level. When you talk to your legislative members, to make sure to remind them that it's great that you passed the law. We're excited that you passed the law, but in order for us to do this correctly, we've got to implement it with the resources that are needed to make that happen. And so you've got some pretty important members in the legislature that are right here in your community. Mr. Strickland is a representative from this area and serves on the JPS committee. And so those are people that it would be important to talk to. Anybody that's on that Justice and Public Safety Committee about the additional funding that we need to make this work right. There was money for Kim's office. Kim from the Indigent Defense Office was recommended in the recommendations, included in the governor's budget, but was not included in the legislative budget. And that was to basically establish additional position in the Indigent Defense Office so that we could provide training to our defenders across the state on how to do juvenile law. And then the last one was the Administrative Office of the Court's recommendation. And these are additional positions that you see listed here for district court judges, ADAs, legal assistants, and for deputy clerks. And those were all recommended not to be put in place until January of 2020. So they're not included in this year's budget, but these are all things that have been requested moving forward for Raise the Age. But I think the more important one is this pink box over here, which says that we think it's important that you fund the deficiencies that are currently in the court system today for deputy clerks, ADAs, legal across the state of North Carolina. And we've gotten some progress on that. On that one in the pink box over there, they did fund additional positions for ADAs last year, and that was also included in this year's budget, additional positions for ADAs and for deputy clerks. There were additional positions put in place for deputy clerks, I think over 70 positions over the 2-year process for those 2 roles. These other positions that you see here are all ones that are based off the workload formula. And if you're an AOC person, you probably understand that better than I do. And so, or maybe you don't, I don't know. But those are where the additional numbers that you see there listed are from. All right, so that's the main part of the presentation and the recommendations that have been made so far. Why don't we take a 10-minute break and we'll come back and answer questions that people have and take additional recommendations that people have.